With me here now to analyze for the next couple hours, I have with me criminal defense lawyer Michel Bryant. It's good to have you with me here.
Nice to see you, Lis. How are you?
Good. So we have a very interesting case here, the Elder case, which has really just gotten started. We have the opening statements by the prosecution, which are fascinating. This is, the defense is going to argue this was, just something that had gone bad that night. Just a kind of party, and there was no malintent here. Shouldn't be manslaughter.
I know, and it's been moved from a murder case to a manslaughter case. One, there's a co-defendant we're not seeing. We're hearing a whole lot about.
Right.
But both cases were changed from murder cases to manslaughter cases because of the facts involved.
Right. But they're going to say, look, this was just, I had to defend myself.
Oh, yeah.
I had to defend myself. Now, you're a defense lawyer. Do you like this defense so far?
I think
we haven't gotten there yet, but do you like it?
It's something. You got to work with something. It's really going to depend on how the facts unfold. Because to have a self-defense argument work, there has to be some perception you were threatened somehow. You had something to defend against. But if the evidence unfolds and it looks like the people claiming defense were the attackers, you're dead in the water.
Well, let's walk that through a little bit. How do you, as a defense lawyer, and again, we're so brand new into this case that we don't know really what the defense is going to be, although we have pretty much, the roadmap for it. How do you use self-defense to get your client off in this case with these facts as we know them?
Well, if you believe the defense story, then the defendants, both of them, one in this case, one in a trial to come, were both the recipients of the aggressive action. They didn't start it.
No,
they were just defending themselves.
Exactly.
That the victim came toward one or both of these defendants.
And aggressively. They were the aggressive.
There was initially a story about a broken bottle being held by the ultimate victim. So that's the story we're being told. The evidence at this point doesn't really support that, but it is early, so who knows?
Why do you think the prosecution then would be coming after? Why do you think it was went down from murder to manslaughter then?
Well, I think the series of events makes it look more like it happened and unfolded very quickly at the scene of this intersection. It wasn't. There wasn't the intent necessary. There wasn't the plotting. There wasn't.
Okay, so therefore it wouldn't have been premeditation, which you would need for the murder.
It's more a kind of flying off the handle, escalating event that leads to murder. The intent.
Manslaughter, you mean?
Yeah. Yes, manslaughter. The intent to create some sort of serious bodily harm. Murder results. Manslaughter is really a mitigated murder.
All right, well, thinking that through, though, then why wouldn't this just be pled down at this point? If you've got manslaughter, which obviously doesn't need the premeditation of murder, you've got something more to deal with. If I'm the prosecutor, I've got something more to deal with, to plead with. You're the defense lawyer in this case. You've got something more to go to your client with. We both, if we're both pairing with some plea negotiations, why don't we just plead this? Why are we going to trial on this then?
Well, I think it's pretty clear that the defendants think they can get off, or get off with something less, a lesser included, some assault, some battery, something that puts them in jail, if at all, for a very short period of time, not 30 years.
Okay, I was going to say, there we go. Just so you know out there, everybody, the maximum they're looking at for this trial, because it's manslaughter with a deadly weapon, is a max of 30 years. So the maximum here, not that they would necessarily get that Elder would get that if he were actually convicted, but the maximum that Elder could get is 30 years. So manslaughter in some jurisdictions is a much lighter penalty than that, right?
That's true.
Exactly. So manslaughter in this jurisdiction is 30 years. So
and remember,
do you think that's what's going on here?
It's certainly a factor, and the defendant's not a spring chicken. So if you were hit with the max and you served most or much of it, you're in your 60s, before you get out. So to that person, it's worth fighting, maybe getting a lesser charge conviction, and you're doing much better.
All right, let's talk about prosecution hurdles. We've heard the opening statement. I thought the opening statement was pretty good. It was really well done. It
to
really
the point.
sort of set the scene. Yeah, set the scene. Very professional. I thought it was very good. What about prosecution hurdles, though? What about getting around that self-defense argument?
Well, the big hurdle, I think, for the prosecution is the two different theories of the case. The prosecution is saying, hey, this was two cars that were near one another in an intersection. One passenger approached the other. It escalated. Then we have this stabbing that is orchestrated allegedly by the two defendants.
Right.
That's their story. The defense says, well, no, this started much sooner than that. This is not a coincidental bumping into one another, not physically, bumping into one another at an intersection. This was a retaliation. This was far deeper than just what happened at that intersection.
It just didn't happen at that moment.
And
exactly.
It boiled from below.
Exactly.
And then that led to the altercation. And if that's the defense position, then if the facts support it, it makes it look more like, hey, they were just defending themselves against retaliation from whatever happened earlier. Right.
Now, interesting that you just said that, if that's what the facts support, because you're really putting the burden, I don't think you meant to necessarily do it, but you're really putting the burden on the defense.
Well, I think the facts as we know them does that already. And you know, you have to give the prosecution some benefit of the doubt. They're putting the case on now.
Right.
Nothing looks better for the prosecution than right now.
It does right now, exactly.
Right? So.
Well, it never looks better for the prosecution when they were putting on their case, unless it shouldn't actually look better for the prosecution than when they're putting on their case. But I think the defense, I mean, there is something to work with here for the defense. So don't you agree with that self-defense argument?
If it were clear-cut, we wouldn't be here talking about it.
Yeah, well, I don't know. I'm not sure I agree with that, because I think there are some times when the defense goes on, even though they have nothing to put on.
But they have nothing to lose, so they figure, let's try.
Look, I think in this case, the self-defense argument, because you've got the two vehicles there, because you have the victim as a potential aggressor in this case, I think there is at least an argument that the defense can make that can say, wait a second, the victim was the aggressor here. I was just defending myself. I'm not saying that's an argument that they're going to win, but I think the defense is going to make that argument, and that's going to be the self-defense argument that we're going to see down the road. But we're still on the prosecution case right now. So bear with us, and we'll be back to the prosecution case in just a minute after this break. We'll see you soon. We're in the Demetrius Elder case, which is in Florida. This is the manslaughter case where he's looking up to 30 years in prison. He actually has a co-defendant, but that co-defendant is waiting to be tried. That trial is not going on right now. While we wait for the testimony to continue in that case, I've got Michel Bryant here, criminal defense lawyers. Thank you so much for being here with me. So we were talking earlier about we have stand your ground law in Florida, and Florida is a little bit different from other states in what they have here. Stand your ground law. Tell me about what you know in this particular case, how it's sort of wrapped out in this case.
Yeah, you know, it's a defense that's sort of an increased self-defense type argument. About 20-some states have this stand your ground prospect, and really, in a nutshell, what it means is you don't have to retreat. That's the bottom line. So if we're getting into a fight, and I pull out a gun, and you say, whoa, I probably shouldn't be here. You retreat, fine. But if you don't, if you just stand your ground, that's in offense. It's a defense. And so if that's allowed in a case like this, it supports the defendant's argument. It allows them to argue a different jury instruction to the jury, and it gives a little more weight to that self-defense argument. But in a preliminary motion, the court in this case said, no, we don't see enough here to support stand your ground. And they cited a couple of inconsistencies in the defendant's testimony. They cited the fact that there was no weapon apparently found on the victim, key elements to allow them to use that defense.
And the weapon was a knife, and there was no knife found on the victim.
Correct. And if you believe some of the earlier stories, there might have been a broken bottle used as a weapon as well. None of that proved to be in evidence or available to the police or anybody else. So once they were taking that off the table, there was no weapon for the victim to be using. How do you stand your ground against no weapon?
So the defense couldn't rely on that.
They're stuck with good old-fashioned self-defense.
Good old-fashioned self-defense. Okay, thank you so much for that. Now we're going back to court in live testimony here. We have the crime technician on the stand. Michael, this is fascinating.
Good stuff.
Good stuff. Okay, so we've got the technician on the stand. Now she's the prosecution's witness. She is on the stand. She is opening up has the beer bottle. Now the beer bottle is what the victim first had, correct?
That's one of the arguments. We're not sure. They haven't linked it up yet.
Haven't linked it up yet. Now, the defense tried to keep the beer bottle out of the stand, or off the stand, or off the exhibits, right?
And I'm not sure why, to be honest with you. I really don't know yet why they would want to do that. So it'll be interesting to see.
Okay. The beer bottle, though, was the first thing, apparently, that was brandished that night. And then, apparently, or allegedly, what was escalated then into the knife, allegedly used by Elder as the fatal weapon against Knight, the victim.
Correct.
Correct. So now we're actually seeing the physical evidence. What did you think about the objection that was made about the blood on the...
You know, I get it. The defense is trying to make it as hard as possible for the prosecution to do their job. But what happened in this case was the defense argued and objected, hey, there's been no evidence there's blood on this towel. We don't want to just hear this officer say that. Oh, great, let's open it and show everybody there's blood on the towel. Let's open it and show the jury. So the prosecution loves that kind of objection, even if it was sustained, as it was in this case.
Okay, let's go right back here for just a second. Well, we thought here that the technician would open up some of those pieces of evidence, that we would see what was inside them. She did not. Maybe if she does, we will get that back to you and we will see that. Michael, what did you think of that? Real quick, we've got to go to a break.
Oh, just, you know, it's too bad. The tease was there, but I'm guessing they thought about whether to show it to the jury yet.
We'll be right back in just a minute. All right, Michael, we were just in Florida with the James Coley case. This is a death penalty case. Remember, the facts in this case are just absolutely horrendous, because shortly after this hearing, we just had the judge on the stand in this hearing. Shortly after this hearing, James Coley walks out of this hearing, gets enraged, and we know the facts from here because the facts have been adjudicated. He kills two people, and in a horrible way.
He tracks them down. Yeah, it's like a hunting.
It's a hunt.
You know.
Perfect word. Hunts them down, right?
Yeah.
And the facts that came out in trial were just, I mean, horrible. They were cowering. There were 4 people in the house. First of all, there were 4 people in the house, and they were cowering. 2 people ran off and were able to get out, and were able to testify in trial. In fact, watching the testimony in that trial of the people that survived and had to look at him, I mean, just heartbreaking, right?
Yeah, I mean, the scenario was not unusual. It's the husband mad and jealous at the ex-wife's new boyfriend.
Right.
They're the targets of the hunt.
Right.
He gets one of them, but not the other. The boyfriend gets away, but the ex-wife is killed, as well as one of her good friends. Yeah, so it's a horrible scene. And now the jury's sitting there trying to figure out if we put this guy to death.
Okay, so now let's look at this scene here today. We're just seeing, now I hadn't seen this, where you actually see him at this injunction hearing. This is the judge here that ruled on the injunction. So we roll back, now we get to sort of peel this back, roll back to before he went into this rampage, this wild rampage. You look at this man at this injunction hearing where he's been told his rights. Are you high on anything? Are you anything, is there anything going on with you? And he's like, no,
seemed all right.
Everything's okay.
Seemed okay.
Right?
Yeah, no agitation, no antics.
Tell me about that.
He just, if this was the catalyst for that day, and that seems to be what the evidence suggests and what the jury believed, I'm waiting. I've not seen the mix of what
happened?
Of fumes or anything.
What happened?
Something happened after he got out the door.
Exactly.
And we do know that there were also a number of phone calls that day from Macaulay to his ex-wife, and they were really not nice. They were unpleasant phone calls.
After this injunction
After the hearing.
Okay, after this hearing. Must have happened after this hearing.
In the very short time between the hearing and the murders, yes.
Or he's just a psychopath that is able to stand there in this hearing and look totally normal at this judge, as we're saying that's this nice-looking, older, elderly man.
With the bow tie.
With the bow tie. He's looking, and he's just standing there going, yes, okay, like anything. It's really frightening.
He's obviously boiling underneath,
but able to look like that. Oh, my gosh. Okay, we're going to go to break. We will be right back with more of this. All right, we're following 2 cases in Florida today. One is the James Coley case, and in there, we're looking at the death penalty. He's looking at the death penalty And we're at that stage of the jury's deciding whether it's going to be a death penalty or life. They've gone home, the jury has, for the day. And so I've got Michel Bryant, who has not gone home. Thank you very much.
Well, I've got to go.
No, you're staying right here with me. You are sentenced for another hour and a half with me.
Okay.
You're sentenced here. So they've gone home, but you have not. And you're going to talk to me about the death penalty right now, Michael, in Florida. So has the prosecution even started to mount what they've got to show to get the death penalty for James Cawley? Because we've talked about a little bit before the break the horrible circumstances, and we started to talk a little bit about what he had done, but the death penalty, prosecution's got to meet quite a high burden here.
Yeah, and they're laying the foundation. We
Right.
can see that. We expected a little more volatility from that injunction hearing that we believe was the catalyst for the events
Exactly.
that day. Didn't quite see that, but it still lays the foundation. This is not a good day for James Cawley.
No.
Okay, so you're laying that road work. So now we would expect to see going forward other evidence of escalation that leads to the egregiousness of what he did. That's the standard they've got to prove, this egregiousness of the crime.
Right.
The jury, on
Beyond
the other
two
hand,
people being dead.
Yes. I mean,
Right.
let's face
They
it,
do.
there
Right,
are
right.
deaths and there are deaths.
Right,
And
right,
there are murders
exactly.
and there are murders.
Right.
So what they need to prove is that level of egregiousness that justifies a jury saying, put this man to death.
Right.
Remember, this is a death-qualified jury, and that means...
Exactly. Explain what that means.
It means there's really two key questions.
Okay.
If you ask somebody if they'll impose the death penalty, and they say, every time, I don't care what happens.
Woo, that's not
Bye-bye.
that's
You're
too
off.
much, right?
Will you impose the death penalty? Never. Under no circumstances.
Bye-bye, you're
gone.
off, right.
So everybody else is kind of in the middle.
Right.
They have to at least be willing to consider it.
Right.
So now, once this prosecution case is laid out, the defense gets to do what they try to do best, is mitigate by, if you think of the prosecution building a wall to keep the defendant in, the defense is now throwing rocks at that wall to break it down, to help the jury think, it was
Not about
bad.
guilt or innocence.
Wasn't as bad as I think it needs to
Right.
be to kill the guy.
Right, exactly. Not about guilt or innocence.
Yep.
We know he did it. We know but it was murder, but it doesn't rise to the level of egregiousness to be able, state of Florida, to put him to death. And that's really now what the prosecution has got to mount. Again, prosecution again bears the burden of proof in the sentencing stage, and the defense is saying, now the defense actually does bear a burden to show mitigation.
Right. There's almost a presumption that the death penalty is appropriate, and the
Right.
defense has to then prove that it should not be.
Right. And the word you used before break, I think, was that he hunted his victims down. There were two of them, and there were four people in the house. Let me ask you this. Does the fact that there were two other people in the house and the trauma that they sustained, does that have to go to egregiousness of the crime?
I would think so. I think when laying out the case, you were going to point out that these others who escaped were
Right.
nonetheless terrorized and thought they were going to die too. So that's all part of the mix, sure.
There are other victims here too. What about on the other side, mitigation? Does the fact, if there are these facts, that James Cawley is a good guy in some other ways, that maybe he does charity work on Sundays. I'm making this up now. I don't know about this. I'm just totally making this out of whole cloth. But if that were to be true, and the defense could that defense bring that in to say mitigate, though he does that on Sundays, he didn't do that this particular day.
Right, too
does
bad.
he do that on Sundays? Does that mitigate against what he did on this horrific one day?
Anything good will mitigate, but to what degree? Is it going to
Right.
be enough to matter? Quite often we see diminished capacity type arguments to mitigate, where they had some sort of PTSD, some stress syndrome, they were on heavy medication. Anything that can kind of, really all you're trying to do is make the jury feel sorry for this murderer. That's a tough job.
Well, yeah, at one point the defense was going to try to say, he was on something. They took that away, so that never became the defense. But it could now become something in this stage, right?
Yes.
Okay. Stay tuned. This is fascinating because, trials don't end, in this case anyway, just when the verdict is rendered. Now they get on to sentencing. And in this case, the jury is part of that determination of whether it'll be, in this case, the death penalty or not. Okay, we're going to take a break from that case, the James Cawley case, and now we're going to go to the Elder case, also in Florida, where we're talking about manslaughter And that in that case, we have the we have a law enforcement witness who's been on the stand for a very long time at this point, but we've got her back on the stand. Let's go see what she's got to say. On the stand for quite a while. We have the bloody towels. We have the beer bottle. She's examined all this. Good for prosecution. She's on cross right now, so. But good for prosecution so far?
Well, it's just, you got to get this stuff in.
Yeah,
I feel a little sorry for her because she's not an investigator per se. She's not out asking questions. She's collecting the stuff that's laying around.
Here's what I've got.
I took pictures. Boom. I collected this. I collected that. Necessary, important, foundational stuff, but she's not going to provide, any sort of smoking gun here.
No. This is all just to get all this information in. But if you're in the jury box right now because this is early on in the crime scene or early on in the trial,
it's always nice to see a bloody towel. Yeah,
it's always nice to see a bloody.
It'll make the jury's day.
That's a great comment. It's also nice. It's always nice to see a bloody towel. Michael, we'll be right back after this break. Thank you so much. All right, they're going to a sidebar now. Michael, what do you think's going on here?
Well, that evidence is clearly important. And the cross-examination is trying to prove that maybe there was some transference. It's typical.
Right. Okay.
If you're not arguing about the chain of custody, you're arguing about transference. I touched these glasses, then I touched this paper.
Right.
Whoa, what a surprise.
Okay.
All that stuff's transferred.
But
his objection was the prosecution's objection to get him to stop may or may not be valid, but she also asked for a sidebar. So there's something he's needling that is doing a job on the prosecution, and she wants to shut him down.
Because what I was thinking right before the sidebar was, this is not looking good if you're the defense in front of the jury, because you're just needling that witness, and it's not looking good for the defense. But I think you're right. They were getting to something. Okay, now we're back to court, though. Okay. Michael, now, it seems like this cross-examination is going on a very long time.
It does.
What do you think?
Sometimes I think a defense attorney who's deep in the woods in a case like this. I mean, he knows more and has forgotten more than anybody will ever care to know. And so with this witness, who's really just laying the foundation for the evidence collected, you want to try and taint. That's right. You want to taint that collection process. You want to suggest cross contamination.
Right.
Okay, have something to work with, but I don't know how much you really need to get into this cross-examination.
Over and over and over again.
Before it's less than effective. Cross-exam should be boom, 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 stick and move out.
Because it seems to me it would have been a lot more effective if he'd gone in and made the point about the cross-contamination, because you make that point about, as you just said, I've crossed from one hand to another, one glasses to another pair of glasses. That's a point that might actually stick with me if I'm thinking about had that beer bottle and the knife and where that blood and the bloody towel and how much blood, how many samples were submitted. Was her what she said, was it followed completely? And she's nodding. I thought that was great. What she said, yes, everything I say goes and submit it. Like,
it's all speculation.
Really?
But
how would she
everybody
know?
Would like to think that you tell somebody to do something and it's done, but we really don't know.
And we all know from our own experiences, our own jobs. Yes, everything I say and in my job, everything is done.
I hear that's what happens.
Well, you know that at Law&Crime, everything that I say, goes. That's what you hear around Law&Crime. And that's true, but Law&Crime. But elsewhere, we know that it may not always be true.
Yeah, you're right.
So I think people in the jury are sort of listening to that, going, that would be a good point to make. But otherwise,
and then you got to move on. You got to move on.
All right. Speaking of moving on, we have to move on right now to a break, but we will be right back on the other side of this break. All right, Officer Peluso is off the stand. She was asked in redirect, does she have any evidence of cross contamination in this case? She said absolutely not. That was the main question that the defense tried to bring up, and she said no. So, Michael, does that sort of tie it up for you?
Well, that's a nice way to wrap things up. Remember, the rebuttal is supposed to be limited to things that were addressed on cross. It was very, she's almost made fun of the defensing. Officer, does it matter whether you were sworn in at the time you were collecting this information? And, of course not.
Right. And she also discovered a T-shirt recovered at the crime scene that looked like it was cut. She said she doesn't know who or why the T-shirt was cut. She said there was no blood on the beer bottle. That might be important down the road. She looked at the crime scene. She said she looked at hundreds of them before she was sworn. So that could be important. I mean, she looked at all of that. So that was her. She was on the stand for quite a long time. Now we have a new witness taking the stand. Let's see what this witness is being now sworn in. Let's go straight back to court, live in the Elder trial. Officer Pelusa, we saw how she got all the evidence and she put it into evidence. And now with this Mr. Komar, we're seeing Michael. We're seeing him, how he got the evidence. He's the DNA expert. He's now been qualified as a DNA expert. He got what Officer Pelusa got, and now he's examining it, right?
Right. He's the DNA guy.
He's the DNA guy.
Everybody wants the DNA guy. In this case, it's interesting because it's not a whodunit.
No,
it's a how-done-it.
Right.
Or if I could say that. Yeah. How was it done?
How was it done? Right.
Yeah. So that's what's going to be important here, where he can put the pieces of DNA to help us understand that.
So the evidence is in. Now we've got the DNA expert on the stand. He's going to put it all together for us in, as Michael so eloquently say, the how-done-it kind of thing.
Yes.
And put it together. And he's an expert in DNA, sort of all different kinds of DNA. So it's going to be very interesting to see what he has to say. So stay tuned. We're going to go to break, and we'll be right back on the other side with the DNA expert. DNA, don't you love it when they have a DNA expert on the stand? I love the numbers that DNA experts come up with. This DNA expert, Christopher Komar, said that it was 1 in 104, let me get the right name, 1 in 104 quadrillion chance that it was Mr. Elder's DNA, that it wasn't Mr. Elder's DNA on this beer spout. In other words, it is Mr. Elder's DNA.
That's about 14 zeros.
Yeah, a lot of. Were you, Michael? Were you doing the zeros?
I'm no Rain Man, but it's a lot of zeros.
It's a lot of zeros. So what this DNA expert is saying is that the DNA is on the spout of this beer bottle. Okay, this famous beer bottle that's now in this case. So what does that mean, and how is this DNA expert performing?
Well, I think he's doing a fine job. Pretty straightforward, easy to understand, believable.
Big numbers,
doesn't look like he's full of himself. So that's always good.
It's always good.
So you've got the defense suggesting that this beer bottle was being wielded by Mr. Knight, the victim.
Right.
Well, now we know that his DNA wasn't on the spout of the beer bottle.
The spout of the beer bottle.
And they didn't test anything else. They didn't test the jagged end of the beer bottle. They didn't test nothing else. So I don't know how many people hold a beer bottle just by the spout. I don't know. And would it be held in this way, or would it be held like this when you're drinking? I don't know. But we know his DNA is on there, and most importantly, the victim, Mr. Knight's DNA, is not on there. So it's tough to argue he was using it as a weapon to threaten either defendant when his DNA is not on.
So what does that mean for their self-defense argument?
Well, it doesn't help. No, it doesn't help at all.
It goes away.
It doesn't kill it, but as you can tell by cross-exam, they're trying to suggest sometimes you don't leave DNA when you touch something. And the DNA expert said, you're right, sometimes you don't. Or sometimes it degrades over time and condition. Well, yeah, if it's out in the sun, if the temperature is high, if the humidity is high, all of those things.
Okay, so they're trying to plant, now they're into the reasonable doubt realm.
Of course,
right?
they're trying to
plant reasonable doubt.
Exactly.
But isn't that kind of tough when you've got the DNA expert on? It's not that much time. It's not that much sun. We're not talking about years of degradation here for a sample. I mean,
yeah,
right?
And the DNA expert is, honest. He says, look, I don't know where it was collected. I don't know where it came from. I'm just in the lab, looking at some results from the swab.
Right.
So there are no answers to those questions, but the defense is doing a good job creating something
they're trying
to suspect, to make it suspicious as to whether or not that DNA should have been found on the behalf of Mr. Knight and what was found on the behalf of the defendant.
Cross-contamination, that's the other thing that they bring up.
Sure, always.
Okay, but again, did they get anywhere with that cross-contamination?
No, I don't think so. I think the better argument here is that it is incomplete DNA. There might be DNA that was not detectable.
Tested. Okay, stay with us. More DNA on the other side of the break in the Florida versus Elder case. We'll be right back. Hi, I want to pick up the conversation where we left off with Michel Bryant, and the conversation about DNA in this case, in the Elder case. Do you think DNA will play a critical role? I mean, it's been brought up very early now by the prosecution.
I don't think so. I mean, most cases, I think it plays a bigger role than in this case, in part for the reason we mentioned before. There were 4 people at that intersection.
Right.
Only one of them is not truly involved in this criminal prosecution as either a victim or a defendant, and that's the girlfriend. And so it's not a case of tracking down the person involved. We know everybody that's involved.
We know everybody, right.
But the jury, they like to hear the forensic stuff. Give me some DNA. They want to hear that stuff.
All right. That being said, then, Why is the prosecution, we've talked about the openings, why is the prosecution bringing this expert, the DNA expert that we just heard, Mr. Komar, in so early on in the case? We understand why they had to bring Ms. Pelosi in, the officer. They had to bring the officer Pelosi in. She testified about picking up the bloody towels and the trouser and the shirt, the beer bottle, all of that. But why then follow that up, immediately follow that up then, so early on in the case, so early impressionable with the juries, with the DNA expert, if DNA is not that important?
I think they're using it for the one purpose, and that is to defeat the defense that this was, in fact, self-defense, that Mr. Knight was on the attack. Okay? If they're anticipating an argument that's on the curve,
right,
whatever,
exactly.
take them on. Battle on the curve,
right,
whatever,
exactly.
take them on. Battle on the curve,
right,
whatever,
exactly.
take them on.
Right.
There's no DNA by Mr. Knight left on the beer bottle. So that defeats that argument unless you believe the defense counter, which is, well, you don't always get DNA to stick to something.
Why not use then, though, that as a rebuttal when defense has already brought that up?
Better to hang it out there and diffuse it immediately. Let the jury know that you're not a dummy. I know this is out there. I know it's coming. We don't care. That's like the so what. It's the so what approach. Yeah, there is a beer bottle involved here. And guess what? The victim's DNA is not on it. So what?
In fact, it looks bad now if you, from the prosecutor, if I'm trying to make this case, it looks bad now if you defense, you're going to try to make some big hay out of this beer bottle.
And you get now, the prosecution gets a second chance to reinforce the point that there's no DNA on it from the victim.
Okay, and so it looks now if the defense makes a big deal, it doesn't make anything.
Not unless they can come up with secondary expert testimony that says, no, we found something else on there, and it is connected to Mr. Knight.
Okay, what about the point you made that the beer bottle, the only place it was tested was this one place where, you know, if it had been tested on more places, and this is what the defense could argue, they might have found the DNA, the all-important DNA that would have exonerated my guy.
One swab seems to me to be a little
right.
A little
this
lazy.
is an argument that could be made.
Of course, and we don't know exactly how much beer bottle neck there was, but it's certainly not all but the bottom. It's a lesser part.
Right.
So there was less to actually swab.
And why just the neck? I mean, that's if you're in that consummate, you know, the hypothetical beer bottle fight, wouldn't you swab?
There'd be more of it, you would think.
And
we don't know for sure exactly how much there is, but it's still, I think if they'd swabbed the exact same spot 3 times,
right?
Yeah, I'd feel better about it.
Right.
You know, there wasn't more like, one quick swab, we got to move on to the next item. It just feels a little less than complete.
Well, it goes to, if I'm the defense lawyer here, it goes to me, I would argue, start to being able to argue what the prosecution didn't do. Well, you didn't do this, and you didn't do that, and you could have done this, and you didn't do this here. And what about that cross-examination here? And what about Detective Pelosi? You're not suited up here. You're not sworn in here. I mean, I know these are all small things.
They add up. They can add up.
But they could add up if I'm. Look at me. I'm making it. Michael, you're the defense lawyer over there. I'm the former prosecutor. This is
You're gone to the dark side.
No, never. It'll scare me over here a little bit. Okay. I want to play here for you. This is now, you talked about there were 4 people there at the scene, and one of them was not involved, and one is not, sort of involved in the criminal justice system. We have that one person here that we're going to replay some of her testimony from today, Wendy Gonzalez. She's the girlfriend now of the victim. We want you to hear some of that testimony, and then Michael and I will be on the other side to talk about that. Michael, both start pounding him. Those are her words.
You have to temper.
Boy, that's tough.
This witness obviously was the only one there, not a defendant, not a victim, and yet she's the girlfriend of the victim.
Girlfriend of the victim.
So you're trying to temper that emotion, her desire, I would think, to get justice for her dead friend. With what really happened, So is it embellished? Is it exaggerated? Is it maybe misheard or misseen? I don't know, but she comes across pretty clean. She
really does. I mean, she's sitting there, and your heart just goes out for her. Now, what vantage point she has? Pretty good, right?
Oh yeah.
What she's seeing?
Yeah, she was there. She was trying to help keep her boyfriend alive.
Right, and they're just now. The jury believing her? You think completely?
I think they're going to be weighing, just like anybody would. Her position, her perspective is somewhat tainted because it was her boyfriend. But she was there, and she comes off credibly to me, it seems.
Yeah.
They're going to have to make that decision. That's what the jury does.
Okay, Michael, boy, thank you so much for being
pleasure.
here. Michel Bryant, thank you so much for being here for these 2 hours with me. I have an amazing giveaway to talk to you about on lawandcrime.com. All you have to do, there it is right there on your screen, is go to Law and Crime icon there and click onto it. You can win 2 tickets to CrimeCon 2019 with a hotel stay. Best part of this, though, is you get to meet Dan Abrams. Well, I've known Dan for, oh gosh, dating myself for 15, 20 years. He's a great guy, I promise you. And a studio tour of Law and Crime Network. And if you come on a Tuesday, I'll be here, so I'll get to say hey to you. Includes a night hotel, travel vouchers. It's going to be an amazing thing for you. Law and Crime lineup. You get true crime books. Oh my gosh, it is just an amazing giveaway. I really think you should do it. I think you'd have so much fun with this thing. And these books you're going to get are amazing. Hopefully there'll be a Hunting Manson in there, one of my books, maybe some murder mysteries of mine that I've written. I mean, and if you're around again on a Tuesday, I'll get to say hey to you. I mean, we really have a fun time. But you'll get to see it all. So tune in, lawandcrime.com, and sign up for it. I got to go now. See you soon.